All right, good afternoon, everyone. Welcome to this week's coronavirus webinar. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows throughout today's program. Once the webinar has finished, if you would take a moment to complete the survey, we would appreciate that, as our presenters do look at your comments and suggestions for future topics. So to start today's program, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. Welcome again to our weekly webinar. We've got a full program for you today. We've also got some late breaking news on vaccines. So to kick us off today, we're going to start with Hermes Fernandez. Hermes is in our Albany office, and he's going to give us a little update on vaccines and the variants and the latest. Hermes, take it away.
Thanks, Pete. Before I talk about vaccines and variants, I do want to mention one thing, because we are now 1 year since the first case was identified in New York. March 2nd was the date that the legislature gave the governor emergency powers. So we really are, we're here 1 year deeply into the epidemic, and looking forward and backwards, as we will do today. Some of the things are so stark in terms of what we've seen, what the differences have been, what the changes have been. In early March of last year, when these emergency powers were given to the governor, and CDC and Anthony Fauci were in the same position, there was a real belief at that time that the state and the federal government had the tools to deal with this epidemic, that individuals would be identified who had COVID quickly, and that they would be isolated, and that the epidemic would be manageable. Within 2 weeks, all of those assumptions had collapsed as we began to deal with the real issues that were presented by a virus that not only was more contagious than had been believed, because we now, the belief today is actually the virus that circulated in New York in March was a variant and was much more contagious than the variant that had been circulating in China originally. And the second thing that was not known then and is known now is that this virus was particularly susceptible to spread by asymptomatic carriers. So by the end of March, the belief today is that New York State and New York City in particular had more cases at that time than were at any other time since within the state. So we've really been dealing with the consequences of all those unknowns. So let me talk about vaccines quickly, because we do have so much good news in the way of vaccines. We have 3 vaccines that are commonly used in the United States. I've mentioned this before. We have the Pfizer vaccine, we have the Moderna vaccine, and we now have the Johnson & Johnson vaccine. The Johnson & Johnson vaccine is just coming onto market. There's not much available yet. There were originally 4 million doses, but that vaccine is going to be produced by Johnson & Johnson and Merck together. That means there will be a great many more doses available. And we're seeing the big changes because of the number of doses of vaccines that are available. On Sunday, the nation hit a record. 2.9 million individuals were vaccinated on Sunday. Remember, the original goals were 1 million a day, which of a country of 330 million meant it would take almost a year to vaccinate everyone. Joe Biden bumped that goal up to about 1.5 million only a month ago, and now 2.9 million vaccines were delivered on Sunday. So that's quite a change and quite an effort. And if you do the arithmetic on these things, there are 250 million adults in the United States. So at that pace of 2.9 million doses with 250 million Americans, we actually are on pace to have every adult American vaccinated who wants to be vaccinated in an 80-day time frame. And that is the end of May. So that would be a very happy development. Now, there has been some, there are pockets of individuals who are not so far seeming to be acceptance of the vaccine. One of the most disappointing, actually, and I don't have a hard number on this, but I was told this yesterday by an individual who is very much in position to know that among workers in his industry, and these are custodial care workers, only 20% have so far accepted the vaccine, and 100% of those individuals are eligible for vaccines even as we speak. Now, right now, to be eligible for the vaccine, right, you have to be over 65 years old, or you have certain pre-existing conditions. The governor announced the change for New York that will be taking place very quickly, beginning tomorrow. The age will drop from 65 to 60. So if you're over 60 years old, you will be able to be vaccinated. On March 17th, which is less than 2 weeks away, all public-facing employees, essential public workers, public-facing building workers, and not-for-profit public-facing emergency workers will be eligible for vaccine. So that's an expansion of the essential workers who are eligible. Keep in mind there that we don't have detail, but essential public workers is, right, those are not for-profit workers. Those are not private company workers. So that's not the counter help in a restaurant, right? That is the public workforce. Public-facing building workers would be people like doormen, and not-for-profit public-facing emergency workers is meant to cover maybe those in certain areas, such as in healthcare, who may not have been covered otherwise. There are still many essential workers who are not covered by the ability to get a vaccine yet, but coming quickly, because we will have enough vaccines available for everyone by the end of May. And because of these developments, we're seeing some very interesting things now. Almost 10% of the country, almost 10% of the adult population in the United States is now fully vaccinated. That means either one dose of Johnson & Johnson or 2 doses of the Moderna or the Pfizer vaccine, and 18% have received 1 dose. You're not considered fully vaccinated until you are 2 weeks beyond your dosage. So 1 dose with Johnson & Johnson, 2 with the others. That means that the vaccine is not considered fully effective until that point. One of the frequent questions is, what vaccine should I get? And there were reports beginning over the weekend that there are people who are actually walking away from vaccine sites because they want the 1 dose Johnson & Johnson as opposed to the 2 dose others. The guidance from all public health officials is take whichever vaccine is available to you. They are all effective. The effectiveness rates have been reported differently because the testings were different. The Johnson & Johnson vaccine is, at this point, is reported to have a lower effectiveness than the effectiveness that were reported on Pfizer and Moderna, but they tested on different populations, and they were tested at different times. The Johnson & Johnson vaccine has been tested against the UK variant, and the UK variant, the United Kingdom variant, is the variant that caused the United Kingdom to shut down again because it is more contagious than than what has been previously recognized as the dominant strain of the vaccine. The dominant strain of the vaccine in New York is changing, and it is expected that the UK variant will be the dominant strain within a month. And that's highly significant because that could affect the effectiveness of some of the vaccines, and it could also change some of the guidance in terms of simply safe social distancing and who can go where and when. But right now, where we are, the new guidance is if you are fully vaccinated, you can be with and entertain others who are fully vaccinated in your home privately. Outside of your home, everyone is still required to wear masks in New York State. And if you're fully vaccinated, you can visit with one other household safely without the need for masks, although masks continue to be recommended. But those are all very positive developments. It shows we are moving on the right track. What is lurking in the background for all of us is the changing the variants, because viruses mutate quickly, and these things, at least in certain circumstances, can be more dangerous and more contagious. They also can be less dangerous. I've been reading various pieces that talk about the common cold, also COVID. There's some belief in various pieces that I've read now that talk about the common cold, what we call the common cold now, at one point had to break out as an epidemic that was very severe, but it mutated over time. Humans built up immunities to it, and we have what we have today. Something that makes you feel terrible, but is not deathly. That may be where we wind up with COVID as well, with the changes over time. The last thing I will mention, just as a heads up, is that we also may be moving to a time in the not too distant future where we will be dealing with what will be called vaccine passports, where if you can show you are fully vaccinated, you will be able to go different places. So you will be admitted, maybe you're admitted to bars, restaurants, casinos. Maybe you can travel to Europe, where the European countries are still refusing various visitors from other countries. Maybe you can go to Canada, right? There's still restrictions in terms of going to Canada. The vaccine passports we actually saw being used in Asia in an alarming way more than a year ago, when this was all new to us, where people were showing that they were COVID free. That's the same sort of idea. You have the vaccine, you show it, show us your ticket, you're in. The vaccine passport will be useful to us. That, in fact, is kind of a mandate, a vaccine mandate in a different fashion, because you will be provided a benefit as opposed to a restriction. You will have access that you would not otherwise have. And I expect to see those types of things developing very quickly in the next few months. So with that, Pete, wear your masks, and I'll pass this on to the next speaker.
Thanks, Hermes. We've got a very popular question here, so I'm going to repeat this, and I suspect Katie will repeat it at the end. But the question is, what's the list of workers that goes into effect on March 17th? Okay. All public-facing public employees, essential public workers, public-facing building workers, and not-for-profit public-facing emergency workers will qualify on March 17th. We're not exactly sure how those are going to be defined. I believe the press conference where this was announced today was sort of closed. So we'll just have to see, but that's the updated list. And I'm sure we'll get some more information. Hermes, any comments on that before we move on to Liz?
No, that's as much as we know at this point. We have a governor who does not take questions, at least during the immediate future.
Okay, thank you for that. We're going to move on to Liz Lehman. Liz has a PPE update. I think Liz is going to walk us through where we are and then provide the latest.
All right, thanks, Pete. Hi, everyone. So what I'm going to talk about today, I thought would be helpful to give an overview of the data behind where the PPP is standing right now. And then I'm going to talk about some updated guidance that the SBA has recently issued. So moving forward, my first slide here is a summary of all the approved lending of the PPP in 2021. You can see here that there have been about $164 billion allocated to current borrowers. In the stimulus bill, allocated $284 billion. So we have about $119 billion left in the PPP. And this data is straight from the SBA. And this was updated on Monday, yesterday. So if you are thinking about applying for a PPP, don't know if you are eligible, there is still a lot of money left. And as some of you may have remembered, last year, there was an 11th hour amendment to the first PPP that extended the application for the PPP about a month and a half. The current PPP is open until March 31st. I do not know if they will extend that or not. I could speculate that they may, but I wouldn't be surprised if we found that out at the 11th hour, similarly to last summer. So the next slide is I wanted to give a overview of the industries that are applying for the PPP, just for your context, if you fall in these industries or if you do not. You can see here that accommodation and food services are the top of the net amount of dollars that the PPP has been allocated to. But then if you go down the line, there's about 300,000 loan counts for agriculture, forestry, and fishing and hunting. So I thought this would be useful for some of you to get contextual, to get a context of where the PPP is going. And then the loan sizes, as you can, this is again, straight from the SBA data. The average loan size for 2021 PPP is $68,000. But you can see that there are a number of higher loans, and I thought this would be useful for your information. So now, so again, open till the 31st. This is where we're at. There's still plenty of money to go around. If you have any questions, I would encourage to contact your attorney. So now I'm going to go more into specific updates. Last week, the SBA updated their FAQs and their regulations, partially to incorporate what President Biden had announced 2 weeks ago. So, which is basically increased eligibilities for certain people, such as people with felonious backgrounds, for people who have defaulted on their student loans, as well as a different calculation for payroll costs for sole proprietors. So there's one FAQ update though, this good faith certification that I wanted to point it out for. We have some clients that for the second draw application, as you know, you have to show a 25% reduction in revenue in order to be eligible for the second draw loan. While some clients met that reduction, they were still a little bit hesitant to apply for the second draw based on the economic uncertainty and necessity certification. The SBA has recently issued this guidance that all second draw PPP loan borrowers will be deemed to have made that required certification concerning the necessity in good faith, because you need to show that 25% reduce in revenue. This is really important. Also, which we had questions from our clients, your first and second draw PPP loans will not be aggregated. This is really important with respect to that loan necessity questionnaire, which borrowers that have $2 million or more have to fill out. So if your first draw is 1.5 mil and your second draw is 1.5, and it will not be aggregated to $3 million, and you will not be bumped up to that higher scrutiny. So then next, thank you, Kathy. So next, I kind of cherry picked some updated FAQs, which I thought would be helpful. And again, there are more, but they're more narrow. So here, the first one to the left of the screen is what happens if you are not fully forgiven on your first draw application? Are you eligible for a second draw? The answer is yes. However, the SBA makes it clear that the borrower must have used the full amount of the first draw PPP for only the eligible expenses. So if you breach the terms of the PPP, then you are not eligible for a second draw. However, if it is converted to a 1% loan, or if you don't get fully forgiven because you have reduced your FTE counts, you are still eligible for a second draw. Another question that I wanted to address that the SBA cleared up was the applicable size standards. So as many of you recall, you could have relied on alternative size standards or revenue-based size standards for the first draw PPP. While it was fairly clear in the regulations before, the SBA recently issued this guidance that you may not rely on these alternative size standards for the second draw. It is a 300 employee hard limit with a very, very few exceptions. So I wanted to bring that to your attention. Okay, so I've been talking a lot about for PPP eligibility. What about the forgiveness prong? The SBA and the Biden administration haven't really updated too substantially the forgiveness process regarding the first and second draw loans. However, there is one big update regarding the alternative payroll covered period. So some of you may know, last year, when the covered period was just a choice between 8 and 24 weeks long, the SBA created for administrative convenience an alternative payroll covered period, where the covered period would begin not on the day that the monies are dispersed into your account, but rather on the first day of the first full pay period for borrowers who were biweekly paying or less. So they have completely eliminated this for borrowers applying for forgiveness for any PPP loan starting in 2021. So this has popped up for some clients where they're preparing for forgiveness for their first loan. Remember, you are allowed 10 months after the end of your covered period to apply for forgiveness before it converts to a low interest loan. So for people or for borrowers who relied on this alternative covered period, and they bring up the application and it's not there anymore. So the SBA really, they eliminated this. And my speculation is because they didn't really explain, but because the covered period has been amended to end within, so it has, the covered period is a minimum of 8 weeks, a maximum of 24 weeks. And you can choose to end your covered period whenever within the 8 and 24 weeks. So the SBA deemed that the alternative payroll covered period was moot because maybe you could just extend your covered period for 1 week. Regardless, if you were relying on this for your FTE headcounts or your salary reductions, you cannot anymore. And so that's the big update, and we will keep you updated as always on PPP. So back to you, Pete. That's all I have today.
Thanks, Liz. Very helpful. That middle slide with the new points really should give people a lot of food for thought. Let's turn now to Stephanie Fedorka. Stephanie is going to give us an update on the relief legislation. This has been morphing a little bit as the legislation has gone back and forth between the House and the Senate with the various approaches. And so Stephanie's going to tell us the latest and what we know.
Thanks, Pete. Welcome, everyone. Thanks for tuning in. I talked a little bit about the relief bill last week, where it had just passed in the House. On Saturday, after several hours of debating, the Senate passed with some amendments or changes. So we're going to talk about some of the key highlights today. Like I mentioned last week, big push to pass by March 14th because of the unemployment benefits lapse on that day. So it's scheduled to go to the House today. So hopefully we will see this in final form in the near future. Next slide, please. So some of the key highlights, stimulus checks. We talked about this very briefly last week. They modified who is eligible. So it's going to be the same initial eligibility, but it's going to phase out much quicker. So individuals who make more than $80,000 adjusted gross income and couples who make $160,000 won't receive any payment. So it is going to be much more narrow of who can receive that payment now. The minimum wage provision, we talked about this last week as well, completely removed. It did not meet the Senate rules for utilization of the budget reconciliation process. Next slide, please. Unpacking the emergency paid sick leave and expanded family and medical leave. So if you recall, the FFCRA leave mandate expired on December 31st. After that, there was an extension of payroll tax credits available to employers who voluntarily elected to provide the FFCRA style leave from the Consolidated Appropriations Act. So that extended the payroll tax credits available through March 31st of this year. So this relief bill would further extend and expand those voluntary, the tax credits available for employers who provide voluntary leave. Next slide, please. So again, totally voluntary. There's not a new mandate for employers who select to extend leave and offer it. They can claim the payroll tax credits through September 30th of 2021. There's a couple of key changes here as well. There's a reset for the paid sick leave. If you recall in previous discussions, there was not a reset in that extension through March 31st. So if your employees use their paid sick leave 10-day allotment back in 2020, it didn't reset. That was it. So it was really only beneficial for employees who hadn't used that paid sick leave bucket. There's going to be a reset starting April 1st. So it resets that 10-day limit for paid sick leave. Leave for COVID vaccination. So it expands and provides another qualifying leave reason that employers can claim for the tax credit. And it expands both for the emergency paid sick leave and the EFMLA credits for leave taken to obtain COVID-19 vaccines or recover from any injury, disability, illness, or condition related to COVID-19 immunization. Also, the language provides a little bit greater, another reason for seeking or awaiting results of diagnostic tests or for medical diagnosis of COVID-19, and the employee had to have been exposed to COVID-19 or the employee's employer has requested such test or diagnosis. So a couple of extra qualifying reasons that employers can claim the tax credit for under the emergency paid sick leave or emergency family medical leave provisions. Next slide, please. It expands the definition of the EFMLA. So it now allows employers to claim tax credits for all qualifying uses under the paid sick leave provisions. There's an increase in the tax credit for emergency family medical leave. If you recall, it was capped at $10,000 per employee. They bumped it up to $12,000, so a little bit more tax credit that you can claim. There's a non-discrimination provision, which provides that employers could not claim the tax credits if the paid leave provided to employees discriminates in favor of highly compensated employees, as defined in the Internal Revenue Code, full-time employees, or on the basis of tenure with the employer. So you can't elect to provide this to just full-time employees, not part-time employees, and claim the tax benefits. Next slide, please. Governmental employers. So if you recall, governmental employers were not eligible to claim the tax benefits. They have now modified that. So 501c1 and 501a organizations can claim the tax credits now, if this passes. So UI benefits, there's an extension of UI benefits currently set to expire March 14th, as I mentioned. This would expand the federal unemployment aid and other provisions to September 6th, which is actually different from the House budget or the House bill. That one had the deadline or the expiration of the benefits in August, so a couple extra weeks. More self-employed and part-time individuals could qualify. Another change from the House to the Senate version is they settled on a $300 federal benefit. Initially, the House had increased that to $400. So they've modified that again, and it's just going to be $300 if passed. And then there also includes a proposal to exclude the first $10,200 of 2020 UI benefits from federal income tax for certain eligible households. I believe the cap is at households that make less than $150,000 per year. Extension of the employee retention credit. It's going to be extended for availability through December 31st of 2021. Currently set to expire on July 1st. The credit, there's also a new credit for startup businesses, which it defines as those that were established after February 15th, 2020, with average annual gross receipts that do not exceed $1 million. So they can claim some tax credit benefits through this employee retention credit bucket. Severely financially distressed employers, those with gross receipts that are less than 10% of what they were in the same calendar quarter in 2019, would be able to treat all wages as qualified wages for the purpose of this tax credit. So a little bit more protection or more benefit for certain employers. Next slide, please. Cobra subsidies and changes. So one of the biggest changes here, there's premium assistance for Cobra continuation coverage for individuals and their families. The Senate version has 100% subsidy that would be paid by the federal government of Cobra health insurance premiums for laid off workers through the end of September. The House version had just an 85% subsidy. Also provides some changes in the plan enrollment option, extension of the election period, and there's also this employer notice provision, which requires employers to provide clear written notice on various topics as set forth in the bill. Penalties do apply for employers who fail to provide the appropriate notice. So once this is passed, employers should be reviewing their Cobra notices and forms to ensure that they're compliant with the most up-to-date information as required by this legislation. The government is supposed to create and develop some model notices, but definitely check on those once this passes to avoid any potential penalties. Next slide, please. Lastly, big changes for the multi-employer pension plans. There's significant financial assistance for severely underfunded multi-employer pension plans, allocated $86 billion from this relief bill. So there's special financial assistance that's not subject to financial repayment obligations. The application process would be established within 120 days, and there's a special partition program. So kind of unpacking this a little bit further, why is this important? What's the impact? There's, a couple hundreds of multi-employer pension plans that cover about 1 million employees or so that are significantly underfunded, that otherwise, are projected to become insolvent in the next few years. The current government insurance program is pretty inadequate in handling that situation. So the proposed legislation would allow severely underfunded plans to apply to PBGC, which is the federal insurance organization that provides, helps with this with the multi-employer pension plans, and you could apply for federal assistance. So it's a lump sum grant, not a loan, that would equal an amount that would allow the plan to continue to pay accrued benefits for 30 years. So there's no reduction in benefits already earned by plan participants based on service to date, and which would be paid out to current retirees or employees over the next 30 years. The accounting for the accrued benefits would be partitioned from the rest of the plan in an effort to protect those accrued benefits. So the government has 120 days to set up this program, and there'd be a 120-day turnaround time for PBGC to respond to applications. So if you are part of a multi-employer pension plan that you might qualify, it's severely underfunded, then apply for relief. So some of this short-term impacts, we might see relief from extra contribution obligation imposed under rehabilitation plans to pay underfunding to date, and long-term relief in the form of potential withdrawal liability. Government grant would be factored into withdrawal liability analysis after 15 years. Plans would be, maybe required to pay a higher premium, but other than that, this might be this seems to be a very beneficial opportunity for these multi-employer pension plans that might be in some hot water. And that's all I have, Pete, on the highlights. So we'll stay tuned and hopefully they'll pass, and we'll provide updates on any changes that we may or may not see.
Thank you, Stephanie. That's 2 weeks in a row. We'll probably have to be back here. Hopefully we'll be back here next week with definitive answers to some of these questions in terms of what's in there. I also would note that I think we will probably spin out this last topic separately next week, the multi-employer pension plan relief portion of the bill, and delve into that in a little bit greater detail, because I know that's an important issue for people who are in those distressed plans, and particularly how that might impact their contribution obligations and the withdrawal liability principles. So stay tuned for that next week, a little preview of what we have on tap for next week. We want to shift gears a little bit. This is not strictly a COVID related topic, some pending legislation under the New York labor law that Andy Bobrek is going to take us through. My suspicion or my feeling is that it's an outgrowth of the pandemic, but it potentially, if it goes into effect, may last well beyond the pandemic. Andy, take it away.
Great. Thanks, Pete. Good to be with you, everyone. The sun just peeked through the clouds here in Syracuse. It's going to be 60, we think, tomorrow. So it's a happy day here. Obviously, there's a lot of positive developments that are taking place with respect to COVID, the rollout of the vaccine. So again, continuing to see positive trends and hearing positive things from our employer clients. I want to touch base on this piece of legislation. I think it's a concern, and I think it's something that I wanted to make sure is on your radar screen for New York employers, or those who employ individuals here in New York or other service providers. I think we've had our attention correctly focused on the Biden administration and changes that we expect to see, legislative and executive. But I also didn't want us to lose sight of the fact that we saw some dramatic changes in the state legislature as well, including supermajorities and now in both houses that have the ability to override any governmental veto from the governor's office. So I'm expecting some pretty significant legislative developments in my area, which is labor and employment. And so these are things I think I want to make sure are on your radar screen. One bill in particular that we'll talk about today is this legislation that's really multifaceted, really two main pieces of it. I'm going to push out a link to the legislation now that you can take a look at. There's a lot of detail in here. We don't have enough time to go into it all today, but I wanted to give you a kind of a high elevation overview of the key pieces. So this legislation has already passed the Senate, and it's expected to pass Assembly as well. I don't know quite yet. I don't have a sense of where the governor's office is at as of yet on this. The legislation would apply to private sector employers and really would apply to any individual who is working for pay in a workplace. So it doesn't just cover employees. It expressly covers independent contractors, home care workers, really a very, very broad group of workers, which we typically don't see in these types of labor statutes. Usually it's the employer and the employees. That's who's covered. This will be much broader. And that'll be significant too when you talk about some of the remedies that are under here. Okay, so what does this legislation do? First, it will require private sector employers to establish and implement an airborne infectious disease exposure plan. What is that going to be? Well, I'll tell you a little bit about it. But it's not specific to COVID, but as Pete mentioned, it really flows from our experiences with COVID and by and large what we've seen in the way of requirements from state officials. So in some ways, it will mirror the types of infection control plans and safety plans that we've implemented to this point, but it'll be broader based. In addition, there's going to be some teeth to this requirement. So it's not just guidance that's being put out. Of course, this is going to be a law, it's going to be required, and there is going to be some serious consequences for noncompliance and an additional scope of protections for employees. Employees who raise their hand and say, hey, I don't think this plan is quite right, or I don't think my employer is following this plan. Again, employees are going to be protected from retaliation for raising a concern about the plan. They're going to be protected from notifying, if they notify government officials about concerns about the plan. And additionally, employees themselves can bring a private cause of action against the employer if they feel that the employer is not following the statute and has an improperly implemented or administered plan. So a very, very significant piece of legislation here. It's notable too that the plan that the employer will develop has to be based on, or at least meet or exceed the standard model plan that the state will establish. It'll be the Department of Health working in collaboration with the Department of Labor, and they're supposed to have, under the legislation, specific plans for specific industries that are relevant to the specific risks in that sector. Again, that sounds like a lot of work that needs to be done. Again, somewhat mirrors what we've seen to this point with what the New York employers have had to implement for COVID. But again, it's going to be broader based. A question in my mind is, and again, we're hearing a lot on the OSHA front, on the federal side of things. Certainly there's a push for OSHA to take a more proactive, firmer role in establishing standard. OSHA, to this point, to my recollection, has just issued guidance, helpful certainly, but doesn't have the force and effect of law. And there are many out there, including the administration, who's pushing the agency to establish some kind of standard. That raises a question in my mind of how if this legislation is enacted, how will that work with an OSHA standard that may be out there? Will that obviate the need for this legislation if we do see an OSHA standard? Stay tuned on that. We'll have some more to report. The other piece of this legislation, so that's the plan. We're going to have to, if this passes, establish this plan. There's going to be a lot that goes into it in terms of PPE provision, cleaning, social distancing, all those things that we've been working on here. But again, it's going to be codified in the law. The next slide that you'll see, we'll talk about the other piece of this. And this is very notable for us too. It will require these same employers, private sector employers, to establish a labor management workplace safety committee. Now, for those of you with collective bargaining agreements in place, this probably sounds very familiar. Indeed, I suspect many of you, if not all of you, have some form of committee that's been established through your negotiations with the union and put in place to address safety-related issues and to meet on a fairly regular basis. This legislation would require those committees to be established irrespective of whether or not you have a labor union at your particular workplace or a collective bargaining relationship. Furthermore, to the extent you have these terms already in a labor contract, it would appear you're going to make sure that your particular committee and its functions meets this new legislative requirement. Some notable takeaways from this in particular. 2/3 of this committee that you'll have to establish need to be made up of rank and file employees. The rest can be supervisors or others who the employer appoints. But again, 2/3 must be made up of rank and file regular employees of this committee. They are, the committee itself, it's not the employer who controls it. It's co-chaired by a representative of the employer and a representative of the employee. I should note, if you have a collective bargaining relationship and a labor union in place at your work site, it's the union who gets to pick who the employees are on this committee. And the functions of this committee is multifaceted, but again, it's an opportunity for the employees. They're there as representatives of the other employees to raise safety concerns or other similar concerns, which the employer is going to be obligated to respond to under the legislation. They'll review policies that are in place or that the employer wants to implement relating to safety that are done in response to a legal requirement. If there's a site visit by a governmental agency, members of this committee have the affirmative right to attend that site visit. In theory, if the OSHA investigator comes knocking, typically it's management that will meet with that individual and walk around with them. Maybe they'll want to meet with employees, but that can vary. In this case, members of your committee are going to have the affirmative right to be physically present during that investigation and on-site visit. If there's reports that are issued relating to safety, the committee has the right to review those. And then meetings need to be scheduled on a regular basis. The legislation talks about at least on a quarterly basis. Concerning the collective bargaining agreement, I wanted to mention and go back for just a second too to talk about that infectious control plan that you're going to need to implement. The legislation also addresses a situation where you have a labor union in place, and it states that you will be required to reach an agreement with the labor union about your infection control plan. If you don't have a union in place, you're going to be required to engage your employees in a meaningful way and provide them with an opportunity to give you input on that plan too. Similar to what we saw with the infection control plan and the employee rights and other service provider rights that flow from that, the Labor Management Workplace Safety Committee requirement also comes with it certain employee protections, that it protects employees who participate as part of the workplace committee, right? They can't be disciplined or retaliated against for raising issues or concerns or participating in that, and creates rights and remedies for employees who feel they're aggrieved as a result. That's a very quick, high-level overview. I encourage you to take a look at the legislation. There's a lot of detail in there. And if folks are interested too, we'll keep you up to date on this piece. There's other legislation too that has been introduced in the past that we could see that there really would be a pretty significant change for employers across the board here in New York. Thanks, Pete.
Thank you, Andy. Interesting legislation, especially for unionized employers who are kind of familiar with this and have been dealing with different forms of this for years. It would be novel to go outside that model. Okay, we're going to finish up today with Katie Anderson. We're a little behind time, but we're going to take time for Katie's presentation because I think there's some fair number of things that deserve hopefully your attention. So if you could stick with us, that would be great. Katie, take it away.
All right. Yes, let's hope we can. I'll go through it fast. You know that I can be pretty efficient in speed. Looking at the numbers, we're still seeing this plateau. We are seeing a gradual decrease, but it is concerning. Highest concentration of cases right now is in New York City and Long Island and the Mid-Hudson Valley. That's where we're seeing the cases. They're all just kind of leveling off, which is concerning. When you're looking at the vaccine rollout, you have 18.4% of New Yorkers have received the first shot. 9% are fully vaccinated. Obviously, I made this PowerPoint before the governor announced that there would be new eligibility requirements for the vaccine. I have put in the chat I copied and pasted parts of the governor's press conference. If you go in there and look at the Q&A, you will be able to find those new categories written somewhere. Hermes did discuss this. I wanted to put it in writing for people to look at. This is the new guidance from the CDC for fully vaccinated people. Something that is important to look at. The fully vaccinated people can refrain from quarantine and testing following a known exposure if they remain asymptomatic. The 90-day requirement that we were talking about last week, that was removed. So under the new CDC guidance, it doesn't matter if you were vaccinated over 90 days ago. But whether New York adopts that will remain to be seen, or whether New York even announces that it's going to adopt that remains to be seen. We have had lots of questions about where is New York's guidance documents? What's happening with the travel advisory? What's happening about return to work exposures? None of the documents that are out there right now are being updated. It's making our lives incredibly frustrating, but I wanted to try to clarify some things that are out there. It appears that New York has decided to follow the CDC guidance, hasn't explicitly said, though, that they are in all instances, but its actions appear to mirror what the CDC guidance is saying. Why that matters is for the travel advisory, for example, fully vaccinated domestic travelers do not need to quarantine upon returning or arriving into New York. I saw a question in the chat about a child. If the child's not vaccinated, the child will still have to abide by the quarantines. So would have to be tested within 72 hours of arriving in New York, and would have to be quarantined for 4 days and tested on the 4th day to leave that quarantine. I put the asterisk there because it does not, the 90-day thing still exists in New York. So in New York currently, if you're a fully vaccinated individual who's received the vaccine within the past 90 days, you do not need to quarantine. I expect that 90 days to fall off, but just so you know, there is a discrepancy between the federal and state guidance at this moment. Exposure. Fully vaccinated individuals who are asymptomatic do not need to quarantine or be tested. Same thing with the 90 days. There is a discrepancy there. Remember, also, they have to remain asymptomatic. And then finally, looking at individuals who tested positive within the past 90 days, There hasn't been a publicly released policy from the Department of Health saying this, but it appears that most local health departments are following the CDC guidance and are not requiring the quarantine of these individuals so long as they remain asymptomatic. Again, we understand that it's frustrating to keep up with this, especially when we aren't being given up-to-date information, but we will be constantly trying to sort it out for you. Finally, and I'll just mention this briefly, the allegations against the governor continue to snowball. We have seen the biggest update was really the Senate Majority Leader calling for the governor's resignation. That's a big hit. You're looking at this the AG investigation. The Attorney General appointed 2 attorneys yesterday, June Kim and Ann Clark. They will be leading the investigation into the governor's sexual harassment claims against him. Kim, notably, is a former top attorney at the U.S. Attorney's Office in the Southern District of New York, has investigated the Cuomo administration in the past in that capacity. So is very familiar with Albany, very familiar with corruption proceedings, and Clark is an employment discrimination attorney. So that will impact, we've seen that impacting the press conferences. They're not press conferences anymore that the governor's having. That's why we don't have clarification in large parts about who is eligible for the vaccine right now. We just can't get access, well, at least the press can't get access to the governor's office for those answers. So we all have to be a little more patient, I guess, in the meantime. And with that, Pete, I'm done.
Thank you, Katie. And thank you to everyone for being with us today. I'm sorry we ran over a little bit, but wanted to get you as much information as possible. We'll be back here next Tuesday with further updates. In the interim, please stay safe and we'll talk soon.